By the way, it is COVID. But I'm feeling better. The medicine they came out with is pretty good. So I'm feeling about 70%. But I'm at 70%. That's 150% for most people, don't you think? And this is why I want to thank our affiliates. I want to thank Sirius Satellite. I want to thank all the platforms who carry this program. Because the insight that you and I discuss and provide on these cases, on the Republic, on the country, the Constitution, we're able to weave them into what's taking place in America so uniquely, not because of me per se, but because this is what we do. This is who we are. We're not paint by the numbers. I don't come to this as a person who spent 50 years in 15 different radio markets. I come to this as a person who started in the biggest market in America, New York. And because of the power of our message, the listenership and so forth spread throughout the country. So let's get started. Some of what I'm about to say you've already heard, because I spoke on Fox, but you haven't heard it the way I do it here on radio. This immunity issue came up early on. President Trump's lawyers said we have a right to immunity. Period. As a president. Period. Why? Because the president cannot function otherwise. The position of the government, that is the Biden administration, officially the Department of Justice and their unconstitutional prosecutor, Jack Smith, was we can prosecute a sitting president or a retired president, even for things they did while president. Now, to be honest with yourselves, if you're honest with yourselves, we're not going to go back and get the video and audio. Almost every legal analyst said that the Trump position is nonsensical. Nonsensical. Slowly but surely, they began to make the case that, well, Smith was too extreme too. But they said that the court will handily and quickly reject Trump's arguments. And then came the oral argument. Well, many of the justices weren't so quick to do that. Not that they were embracing all of the Trump lawyers' arguments, but they were embracing the idea that you would damage the presidency, the institution of the presidency, the Constitution and separation of powers. Many of these legal analysts, some of whom are professors and former professors on other networks, were still at it. But I do, Mr. Producer and I, and others in my crew and staff and at Fox and at Blaze, we kind of laugh. Because the positions I take are positions based not on ideology. They're based on the Constitution. And how can the Constitution function in a republic? And so on Fox, as one of the few, maybe the only, I don't know, I don't watch it 24/7, but I said, this is not a frivolous challenge by the Trump people. I condemned what Chutkan had done, the district judge. I condemned the 3-judge panel who took about 7 days to dismiss this and gave the Trump lawyers a truncated period of time to even file an appeal. I warned you about Chutkan. I warned you about Circuit Judge Pan, P-A-N. She's a Biden appointee, Chutkan Obama, and I told you that these are dangerous people, as is the Attorney General of the United States, as is the special counsel, that they're going to destroy the Constitution if they get their way. I've also made the point that this pursuit of Trump by the Department of Justice and through this specific prosecutor is an attack on at least half a dozen parts of the United States Constitution. The most important part is separation of powers. But it is an attack on the Appointments Clause of the Constitution, which has now been seriously challenged. And if you read Justice Thomas's concurring opinion with the majority, which nobody's discussed on any network, including Fox, I mentioned it briefly, he embraces the fact that there's been a challenge to the actual appointment of the prosecutor, mentioning Meese, mentioning the landmark brief, and so forth. Seems to me, whether that is formally brought up or not, it is a very important point. So we have the Appointments Clause, separation of powers. When you look at this case and the Florida case, the First Amendment with this gag order nonsense, due process under the Fifth Amendment, and the right to competent counsel under the Sixth with the attack on attorney-client privilege that took place in the district court in Washington, D.C., questions raised about the sufficiency of the search warrant that led to the FBI SWAT team. Of course, questions to come about presidential declassification, but even questions about the use of classified information in an open courtroom. I can tell you from my own experience as Chief of Staff to an Attorney General, Edwin Meese, in the Reagan administration, the reason a lot of these big spy cases with these American spies who spied mostly for the Soviet Union deserved the death penalty but didn't get it, was because our Constitution requires, to the fullest extent possible, public trials, for reasons you can understand. And so the issue of what classified information can be used at that public trial was so daunting and so complex that we tended to negotiate for life sentences because we didn't want to reveal the classified information, which kind of defeated the point, right? That's not so in this case with Donald Trump. What Jack Smith is saying, just so you know, as a side point in Florida, is he wants as little classified information as possible, even shared with the defense, because they can't be trusted. So how are you supposed to have a trial of any kind? And Trump's not going to plead to crap. But all these efforts, in the January 6th case, the documents case, attacking all of these aspects of the Constitutions, raising these questions, most of them, for the first time ever, and then demanding that the courts move quickly. This guy Smith went to the Supreme Court on immunity, said we need to act quickly. They said, no, we don't. They ruled against him unanimously. This guy goes to Judge Cannon's courtroom. He sits there, tries to stare her down. His subordinates treat her with disrespect. The media treats her with disrespect. She's doing exactly what you're supposed to do. She's got serious motions that are filed, and unlike Judge Chutkan, she's reading them. She's saying these are serious constitutional questions. Some of them questions of first impression. I've got to deal with them. Chutkan didn't do that, the Obama judge. She just rubber stamping, and she was utterly incompetent in the way she even responded to these, including the obstruction charges. Okay, let's get to immunity now. What does the Supreme Court, what does the Constitution of the United States say about presidential immunity? Nothing directly. And yet they did debate the issue of how do you deal with a president who violates not just criminal laws, they didn't have a criminal code at the time, but it violates even more broadly and more importantly societal norms, undermines the civil society. In other words, does grave damage to the country itself. And so they created the impeachment clause. Indicting a sitting president. There was some generalized discussion, but they came up with impeachment. They didn't invent it on their own. They looked at what the British were doing with impeachment, and then they stylized it for an American small r Republican constitutional system, understanding they wanted separation of powers. Power, as I say over and over again, power competing against power. That's what they wanted. They're worried about tyranny in many forms. Tyranny of a centralized government. They didn't want to create a president who was a monarch. On the other hand, they didn't want a mobocracy, tyranny of the legislature. The American Revolution overlapped the French Revolution. They wanted nothing to do with mobocracy and pure democracy. They wanted nothing to do with monarchy, and today we call it dictatorship, centralized power. And so they took Montesquieu's words from the spirit of the laws. Power checking power, mixed government. Aristotle talked about a mixed government. He certainly wasn't the only one. John Locke talked about potential of three branches competing against each other, but he didn't detail it. Montesquieu did. A legislative, a judicial, an executive. Just a couple pages in a well over 1,000-page book. Turned out to be a book. And as I've told you before, he was the most important philosopher during the constitutional period. The most important philosopher during the revolutionary period was John Locke. But it was Montesquieu for these purposes, and he's cited a few times in the Federalist Papers. And he's cited specifically for this, separation of powers. Something very perverse that nobody talks about, but it's true. And I'll get to the nub of this case in a minute. The Department of Justice obviously didn't exist when the Constitution was ratified. There weren't U.S. attorneys, there weren't federal prosecutors, let alone special prosecutors. On the one hand, the executive branch is considered a unitary branch. What does that mean? It's the presidential branch. He's the executive. He's the commander-in-chief. He is the executive branch. And yet, you can have the executive branch, that is, people with inferior powers, investigating the head of the executive branch. See what I'm saying, Mr. Producer? So you literally have subordinates investigating the constitutional unitary head of the executive branch. And so we as a society, but government more particularly, has struggled with this. They've come up with an Independent Counsel Act of these special prosecutors and so forth and so on. It would be bizarre in the extreme if an inferior officer of the executive branch had the power to indict the head of the executive branch for official powers that he's exercising as President of the United States. Do you see what I'm saying? Maybe I'm getting too philosophical.